coerced compliance is point 4, coerced compliance of payment on petitioner by threat of incarceration despite several attempts by petitioner to move to vacate the underlying problem of unlawful termination now recognized as such provided in subsequent court, and which that subsequent court conversations would have come in earlier in this country. Just a little more sensitive to read. People know about that. But anyway, no, it does mention, I'm sorry. It does go. Anyway, so you've already discussed that, and you then said you have supporting documentation of that motion, that order of the judge to, and this would be an appropriate place, it seems to me, where you want to bring in that decision. You said it's only in oral form?
Yes, it's an oral.
Okay.
And that's why I brought the recordings to the committee, because it's on the May 9th hearing, and it's on the July 27th, 2011 hearing as well.
Would you make sure, I'm looking at this and it looks a little flimsy for having a disc, so make sure you and I are straight on that.
Okay.
I do have that, or if you have an extra one, that might be what I'm pretty sure we must have it, but I'll have to go upstairs at some point.
Chair, yes, Mr. Penderbury, if I could just have that date one more time, please. May 9th hearing? May
9th, 2009, and July 27th, 2011.
Which is which?
GAO?
They were both, the one in May was a hearing about GAO fees.
Which statement is in there? Which one does the 100%? Which one?
The switch from 100% to from 50/50 to 100% was at the May 9th hearing.
And what was the key thing in the July 27th?
The key thing was the demand that I pay this guardian litem, so-called guardian litem fees, or be incarcerated. She had also walked in with a billing statement, which I had never seen before, for $17,000 at that hearing. Handed it to me, handed it to the judge. The judge looked at me and said, "You have to pay her this now, this bill." And I objected. I said, "I have not seen this bill before. I don't know what it's for. I don't know what it's about. I can't verify anything on it." He said, "If you don't pay her that, I will have you incarcerated today."
And this is also a fee increase?
That's
this
automatic fee increase of
therefore
17.
automatically requires a hearing, is that correct?
That's correct. But you also have to get notice beforehand, so you can look at
Sure,
it
of course.
and see what it's about.
No, Representative Abar for a question. Yes, me or is that?
Just ask you, is this something, it almost sounds like racketeering to me. There's no process.
Yeah.
That's just what I'm just speaking
about. This is something that actually in its specific form isn't addressed in our report, and certainly could be at the desire of the committee. And I'm not clear why there's something a little more specific on those 2 points isn't included. So
what are those 2 points?
Something to add in.
What are those 2 points?
The arbitrary throwing it 100% and the threat of incarceration to enforce in both cases unlawful, that is to say, unheard increases over the $1,000 cap. The unheard point is still the key point as far as everything you're saying.
Unheard is in there.
Have to have a hearing.
Unheard is response B of Part 3 in our recommendation. Requiring all motions, petitions be brought before the court and determined immediately.
So let's see if that comes up well enough as we get to that point. Otherwise, we'll make it more clearly. We'll need to make it more clearly. It would appear to me if the committee agrees. So let's go to point 5. It says that Judge Arnold also failed to meet even one of the administrative court order requirements. And then the SCAO and FDAO items are again there. For the appointment of Judith Hamilton as a guardian litem, including then there's A, assuring that such persons have standing before the court. Now we have the same documents. That's there. What do we have for, and I'll read this to you. Assuring that such persons have standing before the court to apply for appointment. The noticing of parties, including the noticing of parties of a hearing, including the holding a hearing with the parties and the GL present, and D is confirming that such appointment by the production of stipulations and a report. those are the four, it says for appointment, but that's, oh, I see, okay, all right. So these are the requirements that we'll also see in that document, in the SCAO?
Yes.
And what is the backup? Does that say you're supporting evidence of wrongdoing in that situation, or is it the absence of?
Well, no, I have it right here, and this is the order of the retroactive appointment.
Okay, so that will definitely do the job. Representative, Morgan.
So I guess that brings my previous question, the retroactive appointment, so when did the, I guess there was initial, she was appointed quite some time before all the events that we're arguing about in the petition, wasn't she? Or
Well, the retroactive appointment specifically addresses the fact that she had been operating as a guardian ad litem and without the appointment. So they're attempting to go back 2 years and order that the work that she had done for those previous 2 years was proper. But she did not have an appointment at that time, which is why it's a retroactive appointment.
Okay, follow up.
just from what I heard, I think I saw this on the other documents, there was the position that, I guess she was appointed early on in the divorce and child custody case, and then there was a couple of years where, you know, things were going relatively smoothly and she didn't have work to do, and then became more contentious, and at that point they went and brought back, so I guess there's one school of thought that said that she was still appointed from before, and they were just keeping her on.
Well, what happened, and I have that, it's RSA 461A16, which relates to guardians ad litem. 461A16, paragraph 1, and I have a copy here for the committee. I noticed you have the law books behind you there, too. So it should be in there.
Our law reader isn't here today. Somebody else could do that if they chose to, or to find one. He's got it, not
I have a copy here. And I'll just read, I'll read and I'll pass this down to the committee. The last sentence under the first paragraph says, the guardian ad litem may be appointed to continue to serve after the final decree of divorce has been granted. So you're correct, the guardian ad litem can be reappointed back onto a case, but we didn't have a reappointment. She was operating on the case, and then she asked for a retroactive appointment, and that retroactive appointment was granted to her. But, you know, ex post facto laws forbid retroactive appointments in any way. So that is a problem with the retroactive appointment. And the other side is we never had a hearing. We never had a notice. We never had a hearing for her fees. So the elements to have a proper appointment, none of the elements were applied in this instance.
So are these, that's right, now we're going to